of indemnity. 1. There are two parties, viz. The indemnifier and the indemnified, indemnity holder. 2. There is only one contract, i.e. contract of indemnity against loss between the indemnifier and the indemnified. 3. It is a contract for reimbursement of loss. Every guarantee includes an indemnity, but an indemnity does not include a guarantee. 4. In it, the promisor is primarily liable. The undertaking is original, and there being no third person, the indemnifier's liability is in itself primary. 5. It is not necessary for the promisor, indemnifier, to act at the request of the indemnified, promisee. 6. The liability under an indemnity is contingent, for it may or may not arise. 7. An indemnifier cannot sue a third party for loss in his own name, he can bring such suit in the name of the indemnified only. Contract of guarantee. 1. There are three parties, viz. The creditor, the principal debtor and the surety. 2. There are three contracts, one between the principal debtor and creditor, contract of loan, the second between the creditor and surety, contract of guarantee, and the third between the surety and principal debtor, implied contract of indemnity. 3. It is a contract for the security of the creditor. 4. The primary liability is of the principal debtor and the surety is only secondarily liable. The undertaking is collateral. The purpose of a guarantee is to support the primary liability of a third person. 5. It is necessary that the surety should give the guarantee at the request of the debtor. 6. The liability is subsisting, existing. Once a guarantee has been acted upon, liability of surety automatically arises, though it remains in a suspended animation till the debtor commits default. 7. A surety, on discharging the debt due by the principal debtor, can proceed against the principal debtor in his own right. Note: in England, a contract of indemnity may be either oral or in writing, while a contract of guarantee should be in writing. In India, there is no such distinction, and both the contracts may be either oral or in writing. Kinds of guarantee, continuing guarantee 7. The function of a contract of guarantee is to enable a person to get a loan, or goods on credit, or an employment. A guarantee may therefore be given for I. The repayment of a debt, or 2. The payment of the price of the goods sold on credit, or 3. The good conduct or honesty of a person employed in a particular office. Fidelity guarantee. Performance guarantee by banks. There are professional guarantors for whom the issue of guarantees or bonds is a financial service, namely, banks, insurance companies or bond companies who issue guarantees at a certain fee. 8. A. Stands surety for B. For any amount which C. may lend to B. from time to time during the next 3 months subject to a maximum of 50,000 rupees. 1 month later, A. revokes the guarantee when C had lent to B 5,000 rupees. Decide whether A. is discharged from all the liabilities to C. for any subsequent loan. What would be your answer in case B. makes a default in paying back to C. the money already borrowed, i.e. 5,000 rupees? Hint: A. is discharged from all the liabilities to C. for any subsequent loan. In case of default by B, A. stands liable to C. for 5,000 rupees. 9. Performance guarantees are virtually promissory notes payable on demand. It is only in exceptional cases that the court will interfere with the machinery of irrevocable obligations assumed by banks. Discuss. A bank guarantee is a sort of an absolute undertaking on the part of the bank under an arrangement with its customer to pay to the creditor whenever the latter invokes the guarantee. It is an independent and distinct contract between the bank and the beneficiary, and it has nothing to do with the state of relations between the guarantee holder and the person on whose behalf the guarantee was given. While ordinary guarantees are linked to and dependent on the underlying transaction, a bank guarantee is an arrangement where the guarantee is independent of the underlying transaction. In other words, a bank guarantee is not and should not be concerned in any way with the rights and wrongs of the underlying transaction between the parties. SL Commodities Limited v Oriental Credit Limited. 1985 to Lloyds Rep 546, CA. When a bank gives performance guarantee on behalf of a party to a contract, the bank is bound by the obligation undertaken by it. Such guarantee is an autonomous contract and imposes an absolute obligation on the bank in its terms. A bank guarantee, for all purposes, should be taken to be a credit note issued by the bank in favor of the person in whose favor the bank guarantee has been issued, and it should be encashable just like a credit note ordinarily, unless the intention of the parties is otherwise. It is not necessary that for invoking a bank guarantee the bank should be informed of all the facts which go to show that the payment had become really due under the guarantee. A bank guarantee is a commercial document. It can be invoked in a commercial manner. The invocation would be sufficient and proper if the bank concerned understands that the guarantee is being invoked. United Commercial Bank v Bank of India AIR 1981 SC 1426. The Apex Court allowed guarantee money to be collected notwithstanding the insolvency of the customer or the state of the bank's relations with the customer. Maharashtra SEB v Official Liquidator AIR 1982 SC 1497. The money is payable on demand and not on breach. Dena Bank v Fertilizer Corporation of India Limited AIR 1990 Pat 21. Thus, the bank is not concerned with the justification, with an unjust demand, for the invocation of the guarantee. If a bank has unconditionally guaranteed the payment of price on the supply of goods by the seller to the buyer, the bank is bound to honor this obligation, and in the event of any dispute between the seller and the buyer, with goods being of inferior quality and the sellers had not sent the original shipping documents, the buyer cannot obtain an injunction to prevent the bank from honoring the guarantee. Pesticides India v SC and P. Corpin. AIR 1982 Dale. 78, Syntax, India, Limited v Vinamra Impex Inc. AIR 1986 SC 1924. Performance bonds must be honored in the absence of notice of clear fraud. The court gave no guidance as to what constitutes fraud, except this that it must be very clearly established. Himadri Chemicals Industries, P. Limited v Coal Tar Refining Co., 2007, 8 SCC 110. The type of rare case in which a court may intervene was before the court in Banerjee and Banerjee v Hindustan Steel Works Constructions Limited, AIR 1986 calories 374. In this case, the party claiming under the guarantee failed to point out the precise amount of his claim although he had the means to quantify it, his intention being to suppress vital information. The court held that his conduct being fraudulent, enforcement of the guarantee ought to be stayed. Even the winding up of the company on whose behalf the guarantee was submitted would not enable the bank to refuse payment. Gas Authority of India Limited v Official Liquidator, Mumbai AIR 2004 Bomb 220. Where the bank guarantee was invoked within its validity period but its payment could not be released because of a court stay order, and before the stay could be lifted, its period expired and there being no renewal, the bank refused to pay. The Apex Court held the refusal to be wrongful. It was the same guarantee which had been invoked and of which payment remained suspended because of the stay order. Bank of India v Nangia Constructions, I.P. Limited, 2008, 7 SCC 290. The court pointed out that international business wholly depends upon bank guarantees. Banks should not try to avoid payment by resorting to subterfuges. In Syntax, India, Limited v Vinamra Impex Inc., AIR 1986 SC 1924, the Apex Court observed, commitments of banks must be allowed to honored free from interference by the courts. Otherwise, trust in international commerce would be irreparably damaged. The court added, a letter of credit sometimes resembles and is analogous to a letter of credit. Letters of credit and bank guarantees. A bank guarantee is very much like a letter of credit. In a letter of credit, two banks are involved. The buyer opens an account in a bank in his country which guarantees payment, issuing bank. This bank opens a credit with a bank in the seller's country in favor of the seller. This bank, advising bank, advises the seller as to the documents which the seller has to deliver to the bank and the time within which he must do so. On presentation of such documents, the payment under the letters of credit is released. That is why this system of credit is known as documentary credit. The documents must be in accordance with the contract and should also be presented within the time specified, otherwise the bank can refuse to release promised finance.